When you're seeking a visa to visit or to study in the United States, a student visa or a visitor visa, if you're unsuccessful, you get notified by the consulate that your application for a visa was denied under Section 214B. And the first thing that you think about is, what does that mean? How do I get my visa? I want to visit or study in the United States. I'm going to explain to you everything you need to know about a 214B denial or refusal, including how you can overcome this bad outcome. If you don't know me, my name is Joshua Goldstein. I'm an immigration lawyer in Los Angeles. I help people across the country and around the world reach their immigration goals. People just like you. A lot of people want to live and study in the United States for all sorts of reasons, and a 214B refusal or denial can be a massive setback. Let me tell you a heartbreaking story about a 214B refusal. We were recently approached by someone who told us a horrible story about how their wife's student visa was revoked. They were refused entry at an airport in the United States, treated like a common criminal, and then sent back on the next flight back to their home country. And their F2 visa, student visa, was revoked. They went back to the consulate to apply for a new student visa, an F2 visa, and the visa was denied under Section 214B. They reached out to us because we are considered one of the leading immigration law firms that files writ of mandamus lawsuits. We sue consulates and embassies around the world and USCIS when cases are delayed unreasonably. We do it because the embassies or the consulates have an obligation to give you a decision within a reasonable period of time, and they often don't do it. Because we're known for this type of litigation and this denial under 214B was so upsetting, this person reached out to us and asked us whether we could help. So the first thing that you need to know about a 214B refusal of a student or visitor visa is that a mandamus lawsuit is not going to work. Let me explain. A mandamus lawsuit is a tool to help you if your immigration case is stuck, if you have an unreasonable delay, if you've been waiting and waiting and waiting and waiting and you can't take the wait anymore because you deserve a decision. That's when mandamus is appropriate. But for a 214B refusal or denial, you're not in limbo, you're not stuck, you've got a decision. It's just that the decision was adverse. It was a negative decision. You don't agree with the decision. You want a positive decision. You want to challenge the decision. But it's not because there's an unreasonable delay, which is what mandamus is used for. That leads into point number 2. If you can't use mandamus to challenge a 214B refusal, is there a way to appeal this denial? Is there a way to explain that the consulate made the wrong decision and you deserve your student or visitor visa? The answer is yes and no. Let me explain. There is no way to appeal a decision of a consular officer. This is called the doctrine of consular non-reviewability. This has been upheld by the Supreme Court in a recent case. It says that whatever the consulate decides, even if it's arbitrary or unfair or ridiculous or wrong, etc., there's no way you can appeal that bad decision. Whatever you think of your 214B denial, you cannot file a straight up appeal. But, and this leads to point number 3, there is a way to overcome the denial, and that is by reapplying. You applied for a visitor visa or a student visa and you got denied under 214B. You can file a new application. There's nothing to stop you from reapplying. There's nothing that will prevent you from filing this new application and presenting additional evidence for why you deserve the visa. When you file your new application for a visitor or student visa, you want to make sure that you do a better job and you get a better outcome. How do you overcome the denial? What's the key to success? And this is really important. When you've gotten denied under 214B, you have to understand the basis of the denial so you can understand how to overcome it. Everyone who applies for a student visa or a visitor visa is presumed to be an immigrant. In other words, they think that the real reason that you're seeking a student or visitor visa is because you actually just want to live in the US. And in order to get a student or visitor visa, you have to overcome the presumption of immigrant intent. How do you do that? Well, the way you do it is a little bit backwards. Most people think that the way to get a student or visitor visa is to explain why they need to visit the United States or why they need to study in the United States. I have a scholarship, I have funding, I'm getting my PhD, I have to learn English, I need to do this. They say, my grandmother's in the US, I have to visit her, this is really important, I'm gonna stay here, this is what I'm gonna do. These are the important reasons why I have to visit the US. And they think of all these reasons why they need to visit or study in the US, and that's exactly backwards. The key to success when it comes to applying for a visitor or student visa is to show that you actually have really good reasons to go straight back to your home country when your visa is done. You have to show that you have ties to your home country, that you own property in your home country, that you have a car, that you own real estate, that you have family in your home country, you have a job. I'm just making this up, but these are examples of all the strong ties to your home country that you have to show so that it's clear that when your stay as a visitor or as a student is over in the US, you plan to go back. That's the key to persuading them. And the reason you got the 214B denial in the first place is that they weren't convinced that you were going to overcome the presumption of immigrant intent. They thought you really just wanted to stay in the US. So if you want to win, you have to show that you're going to go back to your home country. If you have gotten denied for a visitor visa or a student visa, it's kind of like when you step on a piece of gum. It gets stuck on your shoe and it's kind of hard to get off. And there's always a little gunk on there. Well, once you get denied for a visitor visa or a student visa, when you go to reapply, they are going to be pretty skeptical of you because of the prior denial. It's going to be a little bit more difficult for you to overcome that presumption of immigrant intent. I often advise people to wait more time till their circumstances have changed. Or sometimes I tell people that it doesn't make sense to reapply because the definition of insanity is doing the same thing and getting the same result. And so I often caution people against reapplying for a student visa or visitor visa after they've been denied until they can build up their case a little more. My law firm does not help people with 214B denials. I'm providing you this information because I care about you and I want to be of value and I want to help you reach your goal, and I hope it's been insightful. Follow me for more tips and information.